Now, let's look at this from a different angle now. That High Court on Tuesday declaring some sections of the Finance Act 2023 unconstitutional. The petitioners had argued, among other issues under contention, that the National Assembly did not involve the public in enacting the finance bill. So it was a win for the government on this front and others after the three-judge bench found that there was sufficient public participation facilitated by the National Assembly during the formulation of the finance bill. Lilian Mully followed the proceedings and tells us more from the side of government.
In consolidated petitions challenging the Finance Act 2023, Busia Senator Okia Omtata and others moved to court seeking to stop its implementation. The petitioners approached the court to have the new law declared unconstitutional, arguing that the Finance Act 2023 was illegal because it did not pass through the Senate as envisioned by the law and did not include public participation. They also questioned whether certain taxes cited in the petition and as enacted by the Finance Act are unconstitutional. And while the three-judge bench comprising David Majanja, Christine Meoli and Lawrence Mugambi ruled that the collection of housing levy only from salaried employees was discriminatory and unconstitutional, it quashed elements of the petition that challenged, among other issues, whether the public participation conducted in the enactment of the bill was sufficient.
There is ample evidence that the National Assembly invited citizens to submit and give comments on the bill by way of letters to various stakeholders and newspaper advertisements. Secondly, the invitations indicated the venues of the public meetings and the manner of submission of written memoranda on the bill.
The petitioners had further argued that the National Assembly erred by not involving the Senate in the formulation of the law. The judges found that National Assembly Speaker Moses Wetangula did not have to seek concurrence from Senate Speaker Amason Kingi on the finance bill, as it was a money bill.
Further, taxation is a function of the national government. Thus, in my view, the bill was correctly processed by the National Assembly because its speed and substance falls within the functions of the national government. It was not necessary for the Senate to be included in the district process.
The petitioners complained that the National Assembly incorporated into the bill 18 additional amendments whose proposals were not subject to public participation. The Income Tax Act, the Value Add Tax Act, Excise Duty Act, Miscellaneous Fees and Levies Act, the KRA Act, Retirement Benefits Act, Alcoholic Drinks Control Act 2010, Special Economic Zones Act and EPZ Act.
It must be appreciated that after the National Assembly has heard the views of members of public and industry stakeholders on a bill, it is not precluded from effecting amendments to the bill before finally passing it.
The court rejected claims that estimates of revenue and expenditure were not included in the Appropriation Act in accordance with the Constitution.
Our view is that the estimates of revenue and estimates of expenditure are part of the budget-making process. Although the bill containing estimates of revenue was not tendered before the court, we ascertained that as part of the budget-making process, the estimates of revenue were included in the approved estimates contained in the Appropriation Bill and the Appropriation Act 2023.
On tax-raising measures introduced by the Finance Act, the court found that
the legislature, in this case the National Assembly, has broad powers to levy tax, so long as the power is not exercised in a manner that infringes or violates provisions of the Constitution.
The court also upheld the 16% VAT on insurance premiums, the digital asset tax and the tax on betting, saying they were constitutional and within the mandate of the National Assembly. Lilian Mully, Citizen TV.